Welcome, future counsels, advocates, and legal scholars. You are tuning in to today's Explainer, which is going to be an energetic masterclass on how regional human rights are actually enforced out there in the real world. We constantly hear about universal human rights on paper, but a right is really only as strong as the machinery that enforces it. So today, we aren't just looking at lofty ideals. We're going to dive deep into the specific legal mechanisms that actually hold nations to their promises. Because, well, here's the fundamental tension of international law. How do you hold a sovereign nation accountable, especially when it fiercely resists that oversight? Let's get into it. All right, think of this as our syllabus for the day. We are taking a world tour of regional law. We'll start with number 1, the anatomy of enforcement. Then we're going to analyze 3 fascinating case studies. Number 2, the African system. Number 3, the inter-American system. And number 4, the European system. And we'll wrap the whole thing up with number 5, the final verdict. Okay, I need every single law student watching to commit this to memory. This is the enforcement triad. You see, rights are completely meaningless without enforcement. So whenever we analyze a regional system, we absolutely must look for these 3 elements. First up, the legal framework. That's the actual founding treaty, where the states agreed to the rules in the first place. Second, the institutional framework, the governing body, commission, or court created by that exact treaty. And third, the implementation mechanism, the actual procedures, things like lawsuits, state reports, or physical inspections that are used to enforce the rights. This triad is literally the lens for our entire masterclass today. Keep it in mind. To start our tour, let's pose a pretty vital question. When we look at global law, we so often default to a traditional Western perspective, right? One that's hyper-focused on pure individual autonomy. But how does the African system differ from those traditional Western frameworks? Keep our enforcement triad in the back of your mind as we explore exactly how this region balances the individual with the broader community.
Okay, let's dive into this. Welcome to Section 2, the African system, a framework built heavily on people's rights and individual duties.
Now, this brilliantly illustrates our triad in action across 2 key eras. On the top row, we've got the 1981 African Charter serving as our primary legal framework, which birthed the African Commission on Human and People's Rights. Their implementation mechanism relies really heavily on states submitting periodic reports on themselves, as well as communications from both state and non-state entities. Then, if we jump down to 1990 with the Child Rights Charter, the institutional framework shifts to a specialized African committee of experts. Now, you might be wondering, why did they need an entirely separate committee? Well, because children are uniquely vulnerable. Standard human rights frameworks honestly often fail to capture their specific developmental and socioeconomic needs, which demands entirely distinct, dedicated reporting and complaints procedures. The paradigm shift we're looking at here is absolutely crucial for international law. I want you to highlight this distinction in your notes. The African Charter uniquely protects people's rights collectively. It recognizes the community, not just individual human beings. And furthermore, on the flip side, it actively mandates that individuals have duties towards certain groups and other individuals, duties to their families, their communities, and their states. And here is a massive legal takeaway for you. While some limitations exist on how rights are exercised, no derogations are ever allowed. Literally, a state cannot legally opt out or suspend these rights, even during a severe national emergency or crisis. No exceptions. So if that's how rights are monitored collectively in Africa, let's cross the Atlantic. Here's your next question. If an individual's rights are violated in the Americas, who do they actually call? Think about the sheer David versus Goliath dynamic here. How does a single everyday citizen take on the full weight and machinery of a sovereign state in the Western Hemisphere? Let's answer that by moving to Section 3, the Inter-American System, anchored by the Pact of San Jose. Notice how the institutional framework evolves over in the Americas. We've got a very distinct dual institutional setup here. The foundational legal framework, the 1969 American Convention, established the Inter-American Commission. Now, it has the mandatory competence to receive petitions from everyday persons, groups, or NGOs. But then we also have the Inter-American Court, a totally separate judicial body that examines cases. And pay attention to the 1988 Additional Protocol. This expanded the legal framework to further cover economic, social, and cultural rights. That is a huge leap. Because let's face it, enforcing the right to free speech requires entirely different legal and enforcement muscles than enforcing the right to adequate housing or unionization. So the absolutely crucial point for any aspiring human rights lawyer to understand here is this mandatory pipeline. You cannot just march straight to the judges. Step 1, your petition has to be filed to the Inter-American Commission. Step 2, the Commission reviews and considers the case. They act as a vital, highly powerful gatekeeper. Now, why have a gatekeeper at all? Because international courts would instantly drown in thousands of frivolous or redundant claims. The Commission basically filters out the noise, acting as an investigative body first. Only if they decide to push it forward, or if a state party brings it, do we actually reach step 3. The case is finally submitted to the Inter-American Court to be heard by the judges under Article 61 of the Convention. That gatekeeping system is incredibly effective for sure, but it relies heavily on the Commission pulling its weight. So what happens when a region decides to invest the massive resources required to build permanent, highly specialized courts and committees instead? I mean, just imagine the sheer scale of that legal undertaking. How did Europe build a multi-layered, highly specialized system over 4 decades? Let's set the stage for Section 4, the European system, a highly developed regional framework. Let's look at how this builds layer upon layer. Europe's legal framework definitely didn't just materialize overnight. Nations do not simply surrender their sovereignty all at once. It's an evolution of trust. It started back in 1950 with the ECHR, securing foundational civil and political rights. Then, it took another full decade for them to trust each other with labor and economic rights in 1961 through the European Social Charter. And then, nearly 3 decades later, the framework evolves to be highly specialized in 1987 with the Convention for the Prevention of Torture, which actually allowed for physical inspections. The crucial takeaway from this matrix is how different treaties birthed entirely different implementation styles. Focus on that far-right column for a second. The 1950 ECHR relies on a court to process formal applications. Classic. The 1961 Social Charter shifted tactics entirely, using biennial paperwork reports and collective complaints. But look at the dramatic shift with the 1987 Torture Convention. Its implementation mechanism moved completely away from the courtroom. It uses literal boots on the ground, a specialized committee conducting proactive and periodic site visits, actually walking into the holding cells to inspect them. It's a game changer. Counsel, definitely flag this structural detail in your notes. Unlike the part-time commissions we saw earlier, Europe has a permanent, full-time court, and it operates with a strict, tiered judicial hierarchy to manage what is a constantly growing caseload. They sit in committees of 3 judges to quickly filter out inadmissible cases, chambers of 7 judges to actually rule on the merits, and a massive grand chamber of 17 judges. Why have a grand chamber? To ensure absolute uniformity across European law, and to definitively settle the absolute most profound, complex interpretations of the Convention. Now, what's truly revolutionary about the torture mechanism, and I really want you to contrast this with the rest of our framework today, is that it is purely preventative. Usually, a court sits back and waits for a victim to file a complaint after the horrific damage has already been done, right? Well, the European Committee for the Prevention of Torture does not wait. They enforce rights actively by walking into prisons, psychiatric wards, and detention centers. They check conditions on the ground to eradicate torture before it ever happens. It is a proactive shield rather than a reactive gavel. Wow, we have covered incredible ground today across 3 continents, analyzing the legal frameworks, institutions, and mechanisms of international law. That brings us to Section 5, the final verdict, evaluating the mechanisms. I'm going to leave you, my students, with this final provocative exam prompt to ponder. Look at the vastly different approaches we've covered today. Between the periodic state reports of the African system, the strict gatekeeping commissions of the Inter-American system, and the permanent, full-time courts and proactive site visits of the European system, which implementation mechanism truly holds sovereign power accountable? Think critically about efficiency, state sovereignty, and true justice. The answer you land on will define the future of your practice. Thank you so much for joining me in today's Explainer. Keep asking those tough questions, and I'll catch you in our next masterclass.